Well, hi there, everyone. This is Linda Baumgarten with the Connecticut Real Estate Investors Association, and we are hosting another episode of the Nuts and Bolts Real Estate Series. This gives me an opportunity to interview professionals that we have to deal with day in and day out as real estate entrepreneurs and give you the cutting-edge, accurate information so that you can be successful and profitable in your business. And today I am really excited to host Yona Gregory. She's from the law office of Yona Gregory, and she specializes in evictions, which we obviously hope that you can avoid by proper screening and other techniques. But from time to time you may need an eviction done, and so I wanted to give you the inside scoop about how that works. So, Yona, are you on the call?
I am, yes. Thanks, Linda. Thank you so much for having me, and hopefully we can give some good information to people to prevent, like you say, prevent the evictions and streamline people into being compliant. And if not, worst case scenario, they'll have to call me.
Exactly. So let's just jump right into this. So how do I start an eviction?
Well, basically, you start an eviction by serving what's called a notice to quit on the tenants. And, once it gets to the point where you think you're going down the road of an actual eviction, just so everyone knows, eviction and summary process mean the same thing in Connecticut, so I use them interchangeably. But once you know it's going down the road of eviction, the best thing to do is call a lawyer. Obviously I want everyone to call me, or call the lawyer that you're used to working with. I just don't want people to self-help at that point and try to do the notice to quit themselves. A lot of times my landlords want to save money and serve the notice to quit on their own. And the notice to quit is the most pivotal part of an eviction. It's where all the mistakes can happen, and that's the part where you really want a professional to handle that. And quite frankly, our office, with our flat fees, we're not going to charge you extra to do the notice to quit, so you're really not saving anything by doing it yourself. Just definitely call someone to start that process on your own. But it is a notice to quit followed by a summons and complaint.
And what day of the month are you allowed to serve the notice to quit?
Well, most people's leases run, the 1st through the 30th, and rent is due on the 1st. So if your rent is due on the 1st, you have a 9-day grace period by law. So a lot of people sometimes, they get confused and they serve the notice to quit on the 10th of the month. But when you think about it, if the rent is due on the 1st and they have 9 full days of a grace period, you cannot serve the notice to quit until the 11th. So you have to give them the 9 days plus their initial day. So, it's really midnight on the 10th where they're in default.
Now, am I allowed to change the lease date to start it on, say, the 25th of the month, and then can I serve it on, say, the 5th or the 6th of the month?
Certainly you can do that. And when we take in a new eviction, we always try to look at the lease, hopefully the landlord, if they have one in writing, we look at the lease and to confirm that it's either, that it's on the 1st, or sometimes people start at mid-month on the 15th, depending on when the tenant takes occupancy. So even if you start it, wherever you start your lease, you've got the day that rent is due plus 9 full days. So as long as you calculate in that grace period, you can serve the notice to quit anytime after that.
Oh, okay, good. That's awesome. All right,
I recommend people do serve on the 11th. What I always tell new landlords is, look, when they sign the lease, tell them, if I don't get the rent from you on the 10th, I serve as a practice. I always serve a notice to quit on the 11th. If you pay up, fine, whatever, but you always want to preserve your rights as a landlord. And if you wait for the 11th to come and go, and then sometimes what happens is, a cycle of excuses start, and you continue to buy into it, and you see yourself at the end of the month, then you haven't served a notice to quit, then you have to start the process. It's just best to start it. Always secure your rights with that notice to quit. You start the process so you don't lose time.
Yes. Yeah, one of the things that I've done recently is I let people know that the notice to quit, I serve that right away. Nobody knows about it except you and me. But once I have to serve the second stage, then it appears in the judicial website, and so now it's public notice. So if you ever want to move someplace else, there's now a public record that you've fallen behind.
Right, absolutely. And a lot of people do want to protect their credit rating.
That's been really great. Ever since that happened, it's been very effective of getting people to pay, quite frankly.
It is a good idea, Linda, to do that. And it's something I use too as a tool of negotiation in court. When it gets to the point where I'm in court, one of the things I can do is offer to withdraw the case. So a lot of times I'll say, as long as you do A, B, and C, the landlord's willing to withdraw the case so that it's not reflected on your credit score. And, people that are concerned about their credit, they're going to respond to that. Some people who have been evicted, 10 times, that's of no concern to them. But hopefully that's some leverage that you have as a landlord because you can affect their credit.
Excellent. And how does that get reported to the credit bureaus, by the way?
Well, that's an interesting question that I know part of it. I don't know 100% of it, but I can tell you that in Connecticut, our evictions, housing courts are not always automatically reported. So when you pull, as a landlord, when you pull someone's credit, you have to go an extra step in Connecticut, and you have to look on the judicial website. And even when you look on the judicial website, I am sorry to inform your members that it's not even 100% because some of the courts within Connecticut don't report online. So in other words, for instance, in the New London courthouse, their evictions aren't reported online. So you actually have to either physically present yourself at the courthouse to inquire about whether someone had been evicted, or sometimes you can call and they'll check that for you. So my suggestion to people is, nothing's foolproof really, but what you can do is if you're renting a property in New London or in a district where does not report online, just make it a habit to call or get to know the clerks and go there and just ask if this person had been evicted.
Excellent. That's really great advice because, I didn't realize that either. But Litchfield County also does not report it. So, it's been very, very helpful to me as a property manager to screen people because I did have somebody who was going to apply for one of my apartments and said she had been evicted 10 times.
Oh, my goodness. Yes, and it's interesting. I mean, it's good that she was at least honest.
Yes.
Most people who have been evicted are not honest, and that's the reason why, we end up where we are. And as a landlord, sometimes, it's a combination of credit score, eviction history, and just, sort of the way you feel about that person. A good read on somebody sometimes can you can maybe overlook being evicted for one time for a legitimate reason or something like that. So it's sort of a combination when you look at a candidate. It's not a deal breaker necessarily that they've been evicted, depending on the background of the story. But certainly if they're honest and say, yes, I was evicted one time, this is what happened, and if you can verify that, with your local housing court, then that's probably a good thing.
Gotcha.
It's
now,
hard to say. I'm sorry, I didn't mean to interrupt you. I was going to just say that sometimes people have not been evicted. So, even checking at all the courts, you never know when someone may lose their job, fall on hard times, and then you just happen to be the unlucky landlord to be around for that occurrence.
Yes. Yeah, especially in today's age. Absolutely.
Exactly.
Now, can I continue to collect rent after the eviction is started?
Yes, many of our clients come to us with the false assumption that once the eviction process starts, they cannot collect any money from the tenants, and sometimes that is what hinders them from wanting to initiate the process. But it's definitely, sort of a urban legend, and it is, as long as you do the eviction properly and there's the correct verbiage in your notice to quit, then yes, you can continue to collect money, but it has to be done properly. That's the key to doing the notice to quit the right way. You've got to have certain language on there. You can go ahead and collect the money. It's not called rent anymore. It's called use and occupancy. But the reality is, once you start an eviction, 90% of the people certainly don't offer any more money. But occasionally they do, and you as a landlord want to be able to collect that money right up until the eviction in court so that you have less money that you're owed on an arrearage.
Absolutely. If they want to give you money, feel free to accept it.
Exactly. And as an attorney, what I do is, if the tenant comes to court and they have any money to offer, whether, something substantial, 3 digits or more type of money, I definitely do an agreement so that I can take the money, get the landlord whatever money is being offered and try to get the tenant paid up through arrearage and continue to work with them so the money comes in. The only exception to that is a landlord who tells me, under no circumstances I want these people out, they're doing something illegal on the premises or something like that. But as your attorney, I'm always going to try to get the money, whatever money I can get on your behalf. I'm always going to try to make an agreement that it incorporates that money.
Correct. Yep. Now, if they don't have a lease, do I still need to evict them, or can I just change the locks?
Yes, unfortunately, changing the locks on anyone is not an option unless you own a hotel and it's someone's rented only for 1 or 2 nights. Once they become, once they are occupying the premises, even as squatters, as they refer to them, you do have to start a summary process eviction action, and there's only one way to get them out, through an eviction. So if a lot of people will say, oh, well, I don't have a lease with them. They just moved in. They moved in with the people who I had a lease with, and then those people left. Whoever you're left with, no matter what their agreement with you or lack of an agreement is, you do have to do a summary process action.
Okay. And when can I change the locks? When am I allowed to do that?
Well,
whether it's an eviction or not,
Yeah, when you you change the locks when you have what's called legal possession. The eviction process is for the possession of the premises, so it's not really about money; it's about the possession. And once the court says yes, you have your possession back, be it through an agreement or a judgment by the court, then the marshal is the one who is able to secure the premises back for you by serving the execution from the court and physically moving out the tenants. At the end of the process, a lot of the landlords will call me and say, it looks like they're out. I saw a moving van. The people downstairs, haven't seen them for a few days. At the end, there's usually signs that will indicate that they have vacated, but short of them giving you the key back or them leaving the key behind for you, then you really have to get a marshal to do an execution before you can change those locks.
Yeah, so if at all possible you want to keep the lines of communication open with the tenant, and do your best to, keep it friendly so that they will let you know, and they will leave you a key. And I like to get them to put something in writing. My name is so and so. I've vacated the apartment on such and such date.
That's excellent advice, Linda, and that's a good thing to do if you can communicate with them at the end and just say, sign this piece of paper. That is the very best thing that you can do. Unfortunately, it depends on where the property is and what kind of tenant we're talking about. A lot of the evictions I do in, say, East Hartford area, where you're dealing with someone who maybe won't be amenable to sort of working with the landlord like that, you kind of have to resort to doing the execution more often than not in those areas. But it depends on what type of property you're dealing with. And certainly, myself as a landlord, in my properties that I personally own, I would even, move the person out, help them with a truck or do whatever you can to just get them on their way in a better place and work with them. That's always going to be the best thing that you can do.
Absolutely. Yeah, absolutely.
It depends. And, it depends on the landlord. It depends on the property. But I always want to make sure that I don't put my landlords at any risk of physical injury, because some of the times, once we serve a notice to quit, the people may become ornery and hostile, and there's just no reason to try to negotiate with them at that point. I don't want to see the landlord try to get them to sign anything or try to even communicate with them, depending on the tenant.
Yes. Yeah, I understand. So I must say I've had pretty darn good luck, and I my tenants are like C type properties, and I think but again, along the way, it has a lot to do with communication along the way, but obviously, if somebody's going to endanger your life, it's not worth it. It's just
no, absolutely not. And that's part of landlording. I think that as your members probably are getting counseling as far as how to get good tenants, how to maintain their properties, those types of things. But all of it goes into sort of the total package of your experience as a landlord. I believe, keep your properties up, maintain them in good condition and into a condition that you would want to live there, and then in turn, you're going to get good tenants that you don't have as many problems with. So it's kind of like build it and they will come sort of a theory, but I understand that not every landlord is able to do that. Some properties are just in a different neighborhood, and it's a tougher area.
Yeah, but I found that too. Is that if you do the repairs within 24 hours, if you do that kind of thing, then you have a better relationship. When things start to slip for whatever reason, and they don't feel like they're being heard, that's when they start acting out, kind of like children sometimes act out. So, you want to be heard and you want to be respected and taken care of. So if you can do it, and sure, depending on which area you're buying your properties in, could be, you may need to visit your property once a day. That if you buy in those particular neighborhoods, if you buy in other neighborhoods, you may only see the property once a year. So,
and I always advocate for a more on-site landlord approach, whether it means you have a property manager who's physically there often, because the more people realize that this is somebody's property, this is someone's caring for it, then they're going to do the same. But if they believe that the landlord that owns the property doesn't care about litter on the ground or doesn't care about a broken window, then they're going to treat it like that. So exactly. You're trying to demonstrate good behavior and then hope that they pick up on it. It's not always the case. I mean, certainly I've done evictions in my own property. Sometimes you rent you take a chance on someone and it doesn't work out. So it happens to everybody. But I do believe responsiveness as a landlord, as you say, within 24 hours you make those repairs, because a lot of times by the time I get to court with tenants, there's a pattern. Usually they could be very angry because they have a landlord who hasn't done anything, and they're going to ruin the property before they leave. I mean, it's not a good idea to take a lackadaisical approach to managing your property. Not every property is going to be perfect. I don't expect anyone's going to put gold faucets in like the Taj Mahal or anything like that. But you have to be responsive, and that's all that you can do. Correct.
Yeah, exactly. I think this is a business, and the people that treat it like a business are successful.
Right.
The ones who think they're going to get rich quick or something like that, or they just think they can set it and forget it, you're not going to be successful. It is passive income. We're not talking about working a 40-hour work week on your buildings. It's very passive for most of the time for the kind of income that you get. But you do need to pay attention to it. So.
Right. I mean, sometimes you're going to need to do, certain repairs for a month. Some of my apartments, I literally haven't gone inside of them in a long, long time because the tenant is just there. Everything's running properly. It's one of those things where it's cyclical. You never know what's going to happen, but you can't expect to be out of the country for a month and not be there for people or not provide them with someone to talk to about the issues with the property. I mean, I paint my properties every year. You just want to demonstrate, look, this is what we're doing. We're planting flowers. We care about this. And the other thing I do tell sometimes landlords that are being, that people are being evicted, I say go to the property more than you normally do. Go out there. These people are living in your property for free at this point. They're stealing from you, and you need to sort of mark your territory. You're out there, you're picking out garbage. You own the property. They do not. Make them feel uncomfortable and unwelcome. That's one thing I do recommend. Obviously I don't want them to, like I said, don't put yourself in danger. Don't have words with them. Just go to the property. You own it. Take your ownership responsibility. Go over there and start doing an outside project. Do something. Make them feel uncomfortable.
Yeah, it's really great advice. By the way, one of the nice things about working with Attorney Gregory is that she grew up in the business of landlording and property management, and she has properties herself, so she knows what she's talking about. So,
and that's one of the things I always come at it. I don't represent tenants in my practice. I only represent landlords because that's where my allegiance lies.
And you actually offer service of a flat fee of $497, is that right?
I do. That's right. I do the flat fee eviction. A lot of people ask me, does that include the court fees? The court fee is $175, and your marshal fees are between $120 and $150 for the service of both the notice to quit and the summons and complaint. So clearly, I couldn't include those fees into the $500, then I would be making like $100. And certainly lawyers work cheap these days, but that would be pennies. So it is $500 flat fee. The benefit to the landlord is they know there's a cap on it. If I'm in court for 8 hours on your case, which I truly am usually not, it could be 3 hours, but you know I'm not billing you on an hourly basis. I'm not going to bill you every time you call me or every time I need to send a fax. So it's just a flat fee. It's a cap. It's over and done with. The only fee that you would have to pay is if the marshal actually has to physically move the person out of the property. I don't collect that fee up front or anything like that. That's between you and the marshal at that time.
Gotcha.
Generally, we don't have to do the move-outs, and I work with marshals who are pretty good at kind of getting the people out before having to do a physical move-out, because that's the last thing you want to do.
Absolutely.
So, we work with people who know, our marshal goes over there, he gives a 24-hour notice, he pokes around, he sees they're boxing up, he sees they're actively moving, and it's a Friday. So he knows that by Monday they're probably going to be gone. So he's not going to book a moving truck for Saturday at your bill. He's going to wait till Monday, come back on Monday, and hopefully the place is cleared out. So whatever we can do to save the landlord that process of the physical move-out, we certainly try to work with marshals who know the deal, so to speak, and know how to get that to happen. That said, this economy, a lot of people just don't really have anywhere to go right now. So if they're going to spend the night in the shelter versus spend the night under your roof, they're going to choose under your roof. So they're going to wait until the last minute, until the marshal physically removes them, and then they'll go to the shelter. So
exactly, which is why it's, as a tactic to help them, if you can help them with a truck, if you can help them with, finding another place to stay, those kinds of things. Sometimes that works out. Now, obviously avoid liability for yourself, but, if you can help the process, make it as pleasant as possible, because your whole goal is to get them to move out. So.
And I liked something you said earlier, Linda, was about treating people with respect, and I think that's one of the reasons why, you have been successful with your tenants, and I think that's one of the reasons that, I do pretty well and not have to do a lot of evictions myself, is because I do treat people with respect. Everybody's from a different avenue in life and those types of things, and by the time I get to court with them, they may not have paid the rent for 6 months, and I really, my own self, I don't have a whole lot of respect for that, but I'm never rude to the tenants. I'm always very polite. I've never had a tenant complain about my treatment of them in court, because the best thing that you can do is just treat them with respect and dignity, and everybody's happy, get them to agree to vacate, and I feel like that helps me in my negotiations with tenants in court versus other landlord attorneys that I've seen that are sort of aggressive with them and disrespectful. It doesn't help the process at all, I guarantee it.
Absolutely. So now, what if someone's a slow payer? Can I start the eviction process to get them to pay on rent? So like say I know that they always pay me on the 15th of each month, but I really want on the 1st of each month. Can I start evicting them?
Well, I think the first thing to do is send them a letter and say, look, you're not in compliance with your lease. The rent is due on the 1st. You haven't through, the 10th. And you want to send a letter about late payments, because otherwise you can complicate a future eviction process. So if someone starts to pay you late, send them the letter and demand payment be made on time. And if they say to you, look, I can't pay until the 15th, and you're okay with that, then modify your lease accordingly and then say, rent is only due on the 15th instead of the 1st, if that's what you so wish to do. But if there's someone who you think is just not paying because they're just simply not compliant, or they're having tough time and you see it kind of spiraling out of control, the thing to do then would be to start the eviction process and tell me, look, I want to do a stay and pay agreement. The stay and pay agreement becomes a court judgment. So I can make that agreement even up to a year. During the next year is sort of a probationary period for that tenant. They understand that if they're a day late or $1 short on what the agreement is, then they can get fast-tracked out the door. So that fast-track, yeah, exactly. So, and that could be a year long. So that agreement during the next year, you call me and you say, look, it's the 12th, they haven't made payment. Right away I file a motion for noncompliance with the court. We don't have to serve them anything. The court, your case is still open during that time. You don't have to repay your court fees or your marshal fees. We file a motion for noncompliance. Sometimes they do nothing and we just are able to move them out. Sometimes they ask for a hearing, and so you basically have one hearing and we try to see what's going on. But it at least requires their compliance with that agreement. And over that year, during that probationary period, they're not tenants in good standing. They're called, they're basically tenants at sufferance, and they're paying use and occupancy. So they know that they're in a compromised kind of a situation. So if they're the kind of people who are going to say, okay, we really want to stay here, I've had tenants go through the year, make all their payments on time, make the arrearage payments if they owed any money, and then just go on to be, outstanding tenants and stay for another 3 years. So it's a way to force compliance, not move them out, and get everybody in order. Sometimes people do need that, and if they know the court is overseeing their rent paying, that they're going to do it.
Interesting. So you almost pick up where you left off, so you don't have to do the notice to quit all over again.
You save yourself fees on the notice to quit, and the and it kills me sometimes. What happens is a landlord will start the process, and then the people pay up, and then they just drop the ball. They don't go to court, and they just drop the process. And then the next month, here we go again. They're late again, and now the landlord has to restart the process. So you never want to do that. Once you start the process, and I tell tenants when they call here, sometimes they call after they've been served, and I tell them, look, we'll go to court. If you want to stay in the property, bring money to court. I'll make an agreement with you. And they do not leave. When they leave the courthouse, they know that if they're a day late or $1 short, they're going to be fast-tracked out the door. They know that. So it's a different.
And that's called a stay and pay agreement. Is that like an official kind of thing, or?
It doesn't say it on that. It's just basically called a judgment by stipulation, and the stipulation is as long as they pay on time per the agreement, they can stay. And I can make the agreement whatever it needs to be, and as part of the agreement, I make them repay all of the back rent, and they repay the attorney fees.
Yes.
So I usually break it up. So the first of the month, their regular rent is due, use and occupancy of whatever it was. They're they don't have to pay it till the 10th, and then maybe on the 20th they pay another payment, and that payment is for arrearage and attorney fees. So it's a small amount, whatever they can afford, $100, $150. And then if either of those payments are late or unpaid, then you can go forward on the noncompliance.
Yeah, and I have to say that I've been lately been very successful in having the tenants pay back the attorney fees. Over time, that's been very helpful. They've appreciated it. But again, if you keep your property in good shape, they start looking around to see what else is available, and nothing else is as nice as your apartment at that price. They figure out, I better figure out how to stay here, right? So it comes back to that.
If they're happy in the apartment, then they'll do the stay and pay. I have a lot of landlords who don't, they just don't keep their properties up, and the tenants come to court. They're angry. They vacate the property. They want to wreck the place. You get what you put into things, really. Yeah. And if you are an earnest, honest landlord, you're trying to do the best you can, you're working in good faith here. It's not to say that someone's going to move. Sometimes people move in and they're inherent complainers, and they're not great tenants, and that happens too. But some landlords really don't do what they need to do, and those tenants don't come to court and want to stay in the property. They want to have their way with the landlord because they're very angry.
Correct. So, they want revenge. So now here's a good question. My tenant has a dog in violation of the lease. So if you have a no dog, no cat thing, what can I do? Do I have to evict them?
Well, you can send them a letter. A letter, really what it is a KPA Notice, and that's a legal document. It's a pre-termination letter, and that's something that a lawyer should probably draft. But basically it gives them an opportunity, a 15-day period, to make any changes if they're not in violation. Getting the dog out, relocating the dog, or if there's people that they've moved in there's a lease that says there's supposed to be only 2 adult occupants, and all of a sudden you've got 4 people in there. You
right.
send them the letter, and it's basically, you're in violation of your lease for the following reasons. You have 15 days to fix this, or we're going forward with an eviction. So if you don't send that letter, you cannot start an eviction. You have got to send this, it's called a KPA notice. You've got to send the pre-termination letter first. And then if they don't get rid of the dog, and if they don't get, whatever else they're doing in there, then you start with a notice to quit.
Gotcha. Okay.
So it's a process, but you do have to do that first part of the process. And you don't want to send a letter as a landlord, you don't want to send a letter that says, I need you to get rid of the dog. Because if you don't send the proper legal letter to them, then again, you're kind of foreclosing out on your rights, because then by the time you call me and say, I told them last month, I sent them a letter and I told them to get rid of the dog. And now it's a month later, they haven't paid their rent because they don't want to get rid of the dog. And now I can't do, I've got to do my KPA notice all over, give them the 15 days. So if you have a problem with non-compliance, the best thing to do is at least call me. I'll even walk someone through the letter, make sure I have that they have everything in there. I don't want someone to send out something that's going to complicate the process. I'd rather spend the time on the phone with them and walk them through it first.
Absolutely. Well, that's great. And then just one last question. So if I own my property in an LLC or a land trust or some other entity other than me personally, can I do the eviction myself?
No, you cannot. Most courts now, suddenly in the past 2 years, they've been cracking down on LLCs. They will not let you file on your own behalf as an individual. So unless you're an attorney yourself, then you can file it. But if you're an individual and you own a property and it's, Linda LLC, then you have got to hire an attorney to represent you. So you don't want to not do it. Then what will happen is you'll get to your court date. You're 2 months into the process. You get to your court date. The housing specialist will say to you, "Oh, this isn't an LLC. Where's your attorney?" "Oh, I don't have one." "Oh, okay. Well, this case is being dismissed. You have to restart this process." Ouch. Now you've wasted 2 months, and you've got to do everything all over, filing fee, everything.
Absolutely. So. And then how long does the process take? So say on the 11th, a notice to quit is delivered. How long from that point on does it take to evict somebody?
Well, I would recommend for a timeline, I have on my website under evictions, I have a video, and it's sort of a kind of a PowerPoint video, and it takes you through the timeline possibilities. There's a lot of variables, but generally, the quickest you're going to be able to get someone out is maybe 3 to 4 weeks. Right. If they do absolutely nothing and you get a default, you can probably get them out in a few weeks depending on your courthouse. But if they file paperwork and motion to reopen, it could take a few months. I hesitate to give a definite time because of the variables, but if you watch my video, you can see at least the required days between service and those types of things. It gives you a ballpark figure.
Yeah, but I think the real lesson here is that you've got to get started ASAP. Don't take people's excuses. Right. This is a business, and the way I put it to people I talk to, I say, look, if you don't pay your cell phone bill, they cut off your cell phone. So housing is no different, and you need a roof to stay over your head. So you pay your cell phone. You figure out a way to go pay your cell phone. No, I don't. The phone company doesn't come to you to pick up the bill. Same thing with your electric, same thing with your gas. With the housing, no, I'm not going to come pick up your rent. You need to pay your rent on time. Otherwise, you'll be turned off, essentially.
And I completely agree with you. And I see so many patterns in this business because I've been doing it for so long and I've evicted so many people and dealt with a lot of landlords. One pattern I see is landlords who say they want to be, quote, nice. I tried to be nice. I tried to be understanding. I don't want anyone to confuse nice with being stupid. Being nice is being considerate. I'm going to be considerate to these people. Nice is, you're considerate, you're a good landlord. But being, just haphazard with your money, it's not nice. It's just lack of respect for your own business and your own self. And like you said, when you call Verizon and say to them, well, I mailed the check and, some sort of random excuses, eventually they're going to cut your phone off. They're not going to be nice to you in that same way. They're going to be polite to you, but there's no concessions made for all of these excuses. And landlords shouldn't do that either. I mean, it's a lot of money on the line every month, and when that first comes and the 10th comes and they owe you $500, $600, $700, whatever it might be, that's a lot of money.
Correct.
And, there's nothing nice about just letting somebody not pay you money. It's not about nice.
Right. And, the consequence of it is losing your property because you can't afford to pay the mortgage or taxes or anything like that. So you're going to be out of the housing business really quickly if you don't learn the proper ways of doing this.
Right.
So, one thing for sure, CT REIA offers a manual on a property apartment owner's guide particularly for Connecticut, but I think it's useful for just about any state, but the leases and all that are approved for the state of Connecticut. So if you're listening to this call, I certainly recommend that you do that. And then I also recommend that you go to Yona's website at yonalaw.com, YONA law.com. It's very easy to remember. And watch the videos, watch the information, and then call her. Be preemptive. As you can tell, she's very generous with her information. So if you're having issues, call as soon as possible, get advice so that as soon as you have to take action, you're ready to do it. So, Yona, thank you so much for this call. Is there anything else, you should let our members or listeners know at this point?
No, just if they come to the meeting, the monthly meeting, I have been trying to be there with my table, and a lot of the members have come up to me with specific questions about what's going on in their buildings. I have a tenant who's doing this, and I'm able to take the time there to flesh out the problem and try to sort it out with them and give them advice. So I'm happy to be there and do that if anyone has any specific questions. Great.
That's awesome. Thanks so much. All right. Well, that wraps up another episode of Nuts and Bolts for Real Estate Entrepreneurs. Thanks very much again, Attorney Gregory, and I look forward to seeing you at the next meeting.
Thanks, Linda. Take care now.